I would also tell you to try to cooperate. If there's no reason to resist arrest, to try to flee on foot, which is a misdemeanor, or flee in a vehicle, which is a felony. There's no reason to try to hide evidence that they're going to find or destroy evidence. That's tampering with evidence. That can be a felony. There's no reason to try to sneak evidence into the jail if they're going to arrest you. That's a felony. Better to turn over a misdemeanor amount of marijuana and have a misdemeanor charge than to try to hide it on your body and then think I'm going to get into the jail and they're not going to find it. Then it's a felony, and they'll tell you that. So don't be obstructionist like that, but you don't have to say I shot JFK either. You don't have to confess to whatever it is you're accused of doing, but be cooperative. Do not be violent. There's a new charge called assault on a first responder that's now a felony. So if it's a police officer, an EMS worker, a fireman, that can be a felony charge. So you don't want to be violent with anybody. Don't spit on anybody. Don't be loud. Don't be cursing. Just sit there and be quiet. If you're upset, you want to cry, that's fine, but don't get mad and don't get violent. They're going to take you to jail if they're going to take you to jail. They're probably going to search you if they're going to search you. You don't have to give consent to search, and I probably wouldn't give consent to search, but if you don't give them consent to search, they're probably going to search you anyway, because they can either search you based on probable cause. Maybe they smell drugs. Maybe they see contraband in plain view. That's called the plain view doctrine. Maybe they patted you down for their safety and yours. That's a Terry v. Ohio stop and frisk. They, under the plain field doctrine, if they feel a weapon or feel drugs, and they give specific articulable facts, they can say that's a gun, that's drugs. They reach in your pocket, pull it out. They don't have to ignore any evidence they find. They can say they smell marijuana. They can have a drug dog walk around your car and the dog alerts. They can run your license and see that you got a suspended license. So now they can arrest you for that. They can search you instant to lawful arrest. If you have any outstanding warrants, they can arrest you for that. Now they can search you instant to lawful arrest. So many different ways. They also can go to a magistrate or a judge that night and get a search warrant to search your person, your car, or your home. And they usually will do that if you say, no, you can't search. If they feel they have probable cause, they'll fill out a probable cause affidavit and they'll go get a search warrant. So you can not consent to the search, but they're probably going to be able to consent. All that really does when you don't consent to the search is make them do it legally right, and potentially might give you grounds to suppress it. But being honest, suppression motions don't work very often. A lot of attorneys talk about, oh, we're going to suppress this stop or suppress this search or suppress a seizure, but very rarely will a judge find that an officer's messed up bad enough to suppress the evidence. An officer would almost have to be stupid, lazy, or corrupt, or a combination of all three to have it suppressible, because there's so many legal ways that they can search you.